Hello everybody. Thank you for attendance. My name is Toshiyuki Kono. I'm teaching private international law in Fukuoka, Japan at Kyushu University. Today I would like to give a very brief introduction of the system of recognition of the foreign judgment under Japanese law. Suppose you file a lawsuit against a Japanese individual or Japanese corporation in your country. But suppose you find out that the defendant has no asset in your country. In this case, you have to enforce this judgment in Japan. Japanese law has a system to enforce foreign judgments. What you need is to fulfill the requirements under Article 24 of the law of civil execution. You don't need particular procedure for the recognition of the foreign judgments. But you need to obtain the declaration which allows execution in Japan by the court. The court, Japanese court, would provide you with a declaration if the foreign judgment would fulfill Article 118 of the Japanese civil procedure law. In other words, to enforce the judgments of your country in Japan, the judgment should fulfill conditions under Article 118 of Japanese Code of Civil Procedure. I would like to explain very briefly and quickly about these conditions. We have judgments of the Supreme Court rendered on April 28, 1998. I would like to use these judgments because it would facilitate your understanding. The case was rather simple. Both parties are Indian nationals living in Japan. The dispute occurred because the defendant refused to pay or fulfill his obligation under the guarantee contract. The lawsuit was filed in Hong Kong. The High Court in Hong Kong affirmed the plaintiff's claim. Besides that, the plaintiff filed another lawsuit seeking for the payment of the litigation costs, including lawyer's fee. It was about 1.2 million Hong Kong dollars. And the High Court of Hong Kong ordered separately the payment of this amount to the defendant. And this order of payment of litigation costs was asked to enforce in Japan through the channel that I described, namely Article 118 of the Japanese Code of Civil Procedure. The defendants lost in the first instance and appealed and lost, and the case went to the Supreme Court. And the Supreme Court dismissed the appeal brought by the defendant. There are 4 conditions to recognize foreign judgments in Japan. First requirement is the jurisdiction of the court which rendered the judgment. In our case, that was the jurisdiction of the court in Hong Kong. Important point is how to judge the jurisdiction of the rendering court. The criteria are thus follows. The Japanese law is the applicable law to determine the rendering court has a jurisdiction or not. In our case, even if Hong Kong law says that the Hong Kong court has a jurisdiction, it doesn't help. The jurisdiction of Hong Kong court should be affirmed according to the Japanese law. And what is Japanese law in this case? We don't have a provision for that. Japanese law doesn't have provisions, black letter laws on international jurisdiction. So, according to the leading theory and also case law, this must be determined by the concept of fairness. And this fairness must be judged, taking various factors in each case into consideration. In this case, the jurisdiction of Hong Kong court was confirmed by the Japanese Supreme Court. So the examination goes to the second condition. Namely, notice should be given to the defendant to give enough time and room for his defense. The notice can be in the form of service. The important thing is that the defendant should have enough time to make preparation to defend himself in a litigation. In this case, interestingly, a lawyer hired by the plaintiff physically went to the defendant place and submitted the notice to inform the defendant of the commencement of the litigation. This would not be acceptable for Japanese law. The Supreme Court requires that official and formal way of judicial assistance should be followed. In the case of Japan, Japan is a member state of the Convention of the Service in Civil and Commercial Matters, adopted by the Hague Conference of Private International Law. This is actually the mechanism to be followed. Interestingly, however, in our case, the lack of the appropriate service, namely the service through the court, was not a big issue because of the appearance of the defendant. The defendant appeared in front of a court and produced his counter-argument. Even in the case where no service was provided, if the defendant appears in front of court, then the court actually has the jurisdiction over the case. What happened then when the service is sent by a post? Or what happened when the service is not accompanied with translation in Japanese language? In Japanese case law, in both cases, the service would not be accepted. Or it means that sending it by post would not be considered as an appropriate notice. So the judiciaries follow the judicial assistance in a formal manner and accompany it with a Japanese translation are very crucial things, as well as this second condition concerned. The third condition is a public policy. If the foreign judgment is rendered under a very unfair manner, for example, the defendant was not given appropriate opportunity to defend himself, then the court would violate the public policy, so it would not be recognized. And also, the amount of damage recovery award is exorbitant. It would also not be recognized by the Japanese court. The typical example is punitive damage award in the United States. The Japanese Supreme Court rejected the recognition of a Californian judgment which ordered the payment of $1.2 million as punitive damage, with the reason that the punitive damage would violate the Japanese public policy. In our Hong Kong case, the issue was litigation fees, the payment of litigation fees, which contains the lawyer's fee. Under Japanese law, lawyer's fee could be included in the payments of defendant only in the tort cases. In the contract cases, each party should bear the lawyer's fee. So the question was that the lawyer's fee of the plaintiff was asked to pay in this case. The Supreme Court said it's not a big issue. Important thing is that if the lawyer's fee is within the amount of the cost which did occur, then the payment can be ordered. So the public policy test was also confirmed in our Hong Kong case. The fourth condition is the reciprocity. In order to recognize foreign judgment, there must be a reciprocity between Japan and the country of the rendering court. how to determine if the reciprocity is given or not. Japanese Supreme Court takes less strict approach. It means Japanese Supreme Court does not require exactly the same conditions of the recognition. Well, let me clarify the situation. The point is as follows. In our case, Japanese court is asked to recognize Hong Kong court. Reciprocity means Japanese judgment should be recognized in Hong Kong. Then the question is under which conditions. And Japanese court takes less strict approach. It means the conditions set up by Hong Kong to recognize Japanese judgments should be more or less similar in important points. If the conditions set up at Hong Kong are vastly different, then reciprocity would not be given, but more or less similar in important points, then Japan would also affirm the reciprocity between Hong Kong and Japan. And it was actually affirmed in this case. So let me sum up. There are 4 conditions to recognize foreign judgments in Japan, namely the jurisdiction of the rendering court, appropriate notice or service, public policy, and reciprocity. If a foreign judgment fulfills these conditions, then it is entitled to be enforced in my country. I hope that this information was useful, and I hope that there will be more opportunities for me to inform you of the law in my country. Thank you very much for your kind attention.